Thank you, Madam Chairman. First of all, I'd like to thank you for invitation, for the possibility to present the speech. I'd like to congratulate on this activity in our strange times and hello from Poland. The topic of my speech is the issue of old public and non-enforcement of judgment in the European Union. A case study it is added because Polish and German recent judgments will be analyzed, discussed, and present. I will use this presentation to make easier understand the sentences discussed as well as the reasoning presented by Polish and German courts of all instances. I'd like also to announce that this research was carried out within the framework of the Central European Professors Network. It is coordinated by the Ferenc Mádl Institute of Comparative Law in Hungary in Budapest. As introductory remarks connected with the main topic, I'd like to point these. First of all, the meaning of old public as the ground of non-enforcement of judgments within European Union, not only within European Union, but generally in international civil procedure. We're talking about cross-border situations, and here the cases connected with infringement of personality rights in a very specific cases of falsifying the history. In these recent cases pending before Polish and German courts in years 2016-2021. Outside, I'd like also to mention the recent opinion of the European Court of Justice Advocate General of 23rd February in this year, 3 months ago, on the interpretation of Article 7, it is to be Article 5 in these Brussels series, and the alternative jurisdiction may be applied as it was when Polish courts judged in the cases that will be discussed. Going to this case study, I'd like to mention judgments of Court of Appeal in Krakow, in Poland, of 2016, as you can see, and this recent one, as well as German courts gave judgments, German courts of lower instances, and then Supreme Court, Bundesgerichtshof, in 2019. We could introduce this judgment with the words principle of mutual enforcement in European Union versus exceptional non-recognition of foreign judgment. And this non-recognition may be, as we know, justified by national public policy clause. Here, it was connected with the freedom called Meinungsfreiheit. The key issues in my opinion is the application of old public clause, as it was mentioned, leading to non-enforcement of foreign judgment within European Union countries under Brussels resolution, both the first one as and the second one. And the second key issue is the limits to freedom of speech and opinion under Article 10 of European Convention of Human Rights. As we will see, European Convention of Human Rights, in my opinion, and in the opinion of my colleague, Dr. Edyta Figura-Guralczyk, who worked with me. We worked together on this topic in last years. We presented the opinion that this article should be taken into consideration in much greater extent than it was. Starting the judgment of Polish Court of 2006. Have a look at this sentence. The defendant was ordered to apologize to the plaintiff by publication in the internet website and maintain for a given period, in a given frame, etc. The following statement. Zweites Deutsches Fernsehen, the publisher of the internet portal, regrets the appearance on this date on this www.zdf portal in the article on the title, regrets the expression, this is the most important fragment, the expression which is untrue and falsifying history of the Polish nation, falsifying history, this is the point. Because suggesting that the death camps in Majdanek and Auschwitz during Second World War were built and run by Poles, and secondly, in this sentence, and apologizes Karol Tendera, who was imprisoned in this German concentration camp for violating his personality rights. His personality rights in the meaning of his national identity, sense of belonging to the Polish nation and his national dignity. I would like also to mention that similar, from technical point of view, a similar sentence was given 2 months ago on 23rd of March, also by Court of Appeal in Krakow, and it was another issue, very interesting problems of substantive law, but finally also in this cross-border situation, also the problem of historical falsification, and the same defendant, it is ZDF. What is similar is the obligation. The defendant was ordered also to publish a statement and apology. We'll see what will happen with this judgment in the future, but in the next part of the speech, we go to the first one, to the judgment of 2016, because we know what happened and we can discuss the further circumstances. Then the German courts of lower instances. As you can see, the regional court in Mainz, and then the regional court in Koblenz in 2017 and 2018 confirmed the enforcement of Polish judgment, the enforcement under the European Union law, under Brussels I regulation. What's important in this judgment and reasoning? The words that the defendant, what he does not deny himself, confirmed that the defendant confirmed that he was using the phrase Polish extermination camps, which is an untrue fact. And German regional court stated that an incorrect statement of fact under German law is not subject to the protection of the fundamental right under the Grundgesetz, under German constitution. So in fact, such an argumentation of defendant was rejected in this moment, but finally, German Supreme Court in Beschluss von 19th July of 2019 gave another judgment, another ruling. Have a look at this sentence. Finally, the Polish judgment of 2016 was not enforced in Germany, was not declared enforceable. Why? It was stated that the enforcement of a judgment, here foreign Polish one, by which the television broadcaster is obliged to apologize for falsification of history contained in this statement. It is Auschwitz as Polish camp. In the opinion of the court of the sentencing state, and for infringement of personality rights, in this case, again, in the opinion of the court of the sentencing state, manifestly infringes the fundamental right to negative freedom of expression and German public policy. The enforcement of a judgment by which the television is obliged to apologize and for infringement of personality rights, here in this case, manifestly infringes the fundamental rights to negative freedom of expression, German public policy. Article 34 of Brussels I regulation was applied. It can be questionable. It is worth discussing as usually the application of public order of public policy clause. The Bundesgerichtshof's reasoning, here this quotation, the description of a program announcement as a falsification of history and as violation of the personality rights of the former concentration camp prisoner, in opinion of BGH, is the result of a judgmental consideration, but not a fact whose truth should be verified. This is a quotation. And what can be also questionable, German Supreme Court emphasizes also that the defendant would have to join the above-mentioned opinion and to make it public as its own, as it is excluded in this case to indicate that the statement results from Polish court. What may, what can, what should be discussed here after this sentence, after such reasoning? Not only the issues of international civil procedure, not only the issues of European Union's law, but also fundamental rights, both from national constitutional perspective as well as from the perspective of European Convention of Human Rights. So firstly, ordre public as an exemption, existing also under European Union law, existing also in light of European Brussels regulation. As we all know, such an exceptional solution exists and, in my opinion, should exist. Secondly, national meaning of constitutional principle of proportionality. The principle of proportionality may shape the content, the application, the national meaning of or public clause of this public policy. But firstly, and we discuss it in the paper, but firstly, the obligation to publish a given statement and apology arising here, judgment in a civil case, was classified as, it can be read so, as forcing to present opinion, as a kind of forcing to present opinion, not exactly the judgment. Secondly, negative aspect of freedom of speech. This category was used as ground of non-recognition in this particular judgment, in this particular situation. And again, it can be discussed. It can be discussed where an obligation ordered by civil court to apologize, to publish a statement, can be analyzed, can be discussed from the perspective of negative aspect of freedom of speech. Negative minus third, this argumentation, in our opinion, should be deepened. It is the character of freedom of speech, the character of freedom of opinion, especially under European Court of Human Rights jurisprudence, in light of Article 10 of Convention. Because this right, as many constitutional rights, human rights, is not of absolute character. It has non-absolute character, and there are limits to it. Fourthly, the evident falsifying of history, with using this expression Polish, for Polish concentration camps, was described in this BGH judgment and its reasoning as view or view, very light view, transit, foreign here of Polish court. And last but not least, not only practical but also theoretical issue arises of costs for the proceeding. 4,000 euro in the situation of pensioner is quite a high amount. And the practical from this perspective, but also the theoretical issue arises. It is the access to the court in this situation, the access to an theoretically automatic enforcement of foreign judgment, a nearly automatic declaration of impossibility of judgment even in other European Unions. And these, the most important topics, are discussed in more detail in the paper. The closing, the general remarks that can be presented here in this moment. Firstly, the observation that there are any of different character recent cases in the area of, according to treaties terminology, judicial cooperation in civil matters, according to the traditional theology, private international law and international civil procedure. We have also, as we could see, the exemptions towards the judgment from other member states. The second observation is the notion, the interpretation, the practical application of the old public clause in action. Here in action, in those Polish-German very specific cases. Then the problematic approach can be observed. It is the kind of treatment, the sentence ordered by court, by civil court from another here neighboring country, was evaluated as view and opinion. Such an impression can be drawn from the wording of the BGH sentence and its justification reasoning. The main issue to be discussed, to rethink, is the limit, or are the limits of freedom of speech and opinion. Not only in light of Article 10, European Convention of Human Rights, but also in light of Article 17. Also, of the negative aspect. These points, these observations will be analyzed, will be presented in written form. Because the time is nearly over, I would like to firstly thank for your attention. I would ask for asking questions in the discussion or via email. I hope that this topic, the issue of old public and non-enforcement of judgments in the with those examples, presenting this case study was interesting in some kind, and those observations that I presented will be discussed in the future. Using chat accessible during our conference, I will send links to online documents. Those documents shows in details the circumstances, reasonings, and the features of the cases that have been discussed by me. Once again, thank you for your attention.